Amelia Hayes was a federal fair housing law attorney who had spent her career dismantling systemic housing discrimination. Her days were spent arguing cases where seemingly neutral policies masked profound civil rights violations against individuals with disabilities. She viewed the law not as a guideline but as an absolute, non-negotiable mandate. Her professional specialty was the meticulous dissection of organizational bylaws that created illegal barriers to housing access. Her solace, and a key component of her own documented mental health condition, generalized anxiety disorder and chronic depression, was her emotional support animal, SA, a calm, thoroughly trained 7-year-old black Labrador retriever named Baxter. Baxter was not a mere pet. He was a legally protected medical intervention and a daily lifeline, and his presence was shielded under the highest federal civil rights statute governing housing, the Fair Housing Act FHA. Amelia had chosen her residence in the exclusive, pet-restricted community of Blackwood Heights with surgical precision, ensuring all her ESA documentation was in impeccable order before closing. Upon moving in, she provided the board with her disability verification, the necessary medical letter requesting Baxter's presence as a reasonable accommodation, and proof of her animal's excellent behavioral record. Under the FHA, the HOA had only 2 legal paths: grant the accommodation, which they did reluctantly, or demonstrate, with credible, objective evidence, that the animal posed a direct, unmitigated threat to the health or safety of others, or that its presence would result in an undue financial and administrative burden, a bar almost impossible for a well-funded HLO to meet. Blackwood Heights President Robert Kline, a retired corporate executive obsessed with maintaining the community's pristine, pet-free aesthetic, grudgingly approved the accommodation but immediately set about a calculated, protracted campaign to make Amelia's life in Baxter's presence impossible. He considered Amelia's accommodation request an invasive blight on his authority. The harassment campaign began immediately, starting with a series of minor, petty citations. The board claimed Baxter's bark volume exceeded community standards, issuing a $50 fine despite the fact that Baxter's infrequent vocalizations were always documented by Amelia's home security camera timestamps to be within quiet hours and well below decibel thresholds. They fined Amelia for unapproved species access after Baxter walked across a small patch of community clubhouse lawn. Even though the FHA requires ESAs to be treated as an extension of the disabled person and granted access to all areas of the property generally available to tenants, Kline then escalated the absurdity, attempting to mandate a specific, expensive genetic test to verify Baxter's breed purity, a clear, baseless attempt to invent arbitrary barriers to her continued residency. When these minor nickel-and-dime fines failed to deter Amelia, who simply filed them away as evidence of pattern and practice of discrimination, the board held an emergency meeting and passed 2 new rules, highly restrictive bylaws targeting large canines rules that were clearly engineered to make Baxter's existence non-viable. The first was the Waste Management Rule, a punitive regulation requiring owners of dogs over 50 pounds. Baxter was 75 pounds to submit daily time-stamped, GPS-enabled photographic proof of all waste disposal into a designated, off-site commercial receptacle, located 4 blocks outside the community and only accessible during specific daylight hours. Failure to submit daily proof resulted in a devastating $150 fine per instance. The second was the Access Restriction Rule, a new bylaw banning all dogs over 50 pounds from utilizing any common pathways or green spaces after 8 p.m., effectively eliminating Amelia's only opportunity to walk Baxter before or after her demanding schedule as a work-from-home attorney. These rules were not accidental. They were transparent, malicious examples of disparate treatment designed specifically to create an undue burden on Amelia and force her to move or relinquish her assistance animal. Amelia, the federal fair housing attorney, saw this not as an annoying local dispute, but as an open, actionable violation of Title VIII of the Civil Rights Act of 1968, as amended, which, under the FHA, explicitly prohibits discrimination based on disability in housing. Kline's board had just made a catastrophic error. They had weaponized their bylaws against federal civil rights law, and they had chosen to harass an expert witness in that exact field. Amelia did not send a cease and desist letter. She knew local litigation would only drag out the inevitable. She did not engage in the HOA's tedious fine appeal process. She had no intention of legitimizing their illegal rules. She moved directly to the federal enforcement mechanism that only a handful of attorneys truly understand. She immediately filed a comprehensive administrative complaint with the Department of Housing and Urban Development, HUD's Office of Fair Housing and Equal Opportunity, FEO, detailing the history of harassment and requesting that HUDA initiate a systemic investigation into the HOA's governance practices. Simultaneously recognizing the punitive and malicious nature of the abuse, she filed a federal civil rights lawsuit against the Blackwood Heights HOA, the entire board of directors individually, and the property management company for violation of the Fair Housing Act, citing both the discriminatory rules and the direct documented denial of the core benefit of her already granted reasonable accommodation. Amelia's HUD complaint was a masterpiece of legal precision and a roadmap for enforcement. It meticulously detailed the history of harassment, provided the medical documentation for her ESA, and included certified copies of the new, egregious bylaws. She argued persuasively that the physically burdensome waste management rule and the total nocturnal access restriction created an insurmountable barrier to her ability to use and benefit from her housing, constituting an illegal de facto denial of her granted reasonable accommodation. Furthermore, the 50-pound threshold was an arbitrary limit known to target her specific animal. The clear, written denial of accommodation and the subsequent creation of targeted, discriminatory rules were smoking guns that, in federal court, would be impossible to defend. The HOA's legal defense was non-existent the moment they attempted to impose the GPS tracking requirement. The arrival of the HUD notice and the federal summons instantly plunged the Blackwood Heights HOA into a state of professional and financial terror. A federal investigation into an FHA violation is exponentially more severe than any local civil suit. HUDA investigators, backed by the full weight of the federal government, have the power to subpoena every single HOA document, including board emails and private minutes compelled testimony under oath, and impose fines that far bypass the HOA's liability insurance caps. Robert Kline's longtime complacent general counsel, recognizing the sheer gravity of the situation, immediately advised the board that they were in a state of extreme legal peril and that their position was wholly indefensible. The board members, who had ignorantly believed themselves protected by their local bylaws, are now staring down the barrel of personal liability for civil rights violations. The HUD investigation was swift and overwhelming. Federal investigators set up temporary quarters in the community clubhouse, demanding immediate access to all records. They quickly determined that the HOA had not only illegally denied a reasonable accommodation, but had also engaged in a persistent, documented pattern of harassment. They found the 50-pound weight limit and the GPS-enabled waste disposal rules to be textbook examples of blatant, discriminatory barriers unsupported by any legitimate health or safety concern, intended solely to harass the disabled resident. They interviewed Amelia's neighbors, confirming the infrequent nature of Baxter's barking and the general peace of the community, systematically dismantling every single one of Kline's manufactured justifications. The final judgment was devastating, ensuring that the financial pain exactly matched the malice of the HOA's actions. Hood levied massive statutory fines against the Blackwood Heights HOA for multiple FHA violations, totaling over $150,000, payable directly to the federal government. Furthermore, the federal court case, recognizing the malice and willful intent, resulted in a mandatory settlement and a sweeping injunctive order. The HOA was ordered to pay Amelia Hayes $85,000 in compensatory and punitive damages for the emotional distress and civil rights violation resulting from the prolonged harassment and denial of full housing benefits. Additionally, the HOA was required to cover all of Amelia's extensive legal fees, exceeding $60,000, ensuring she incurred zero cost for the entire litigation. Finally, the court issued an absolute injunctive order requiring the HOA to immediately repeal the discriminatory bylaws and mandated that the entire board and property management staff undergo extensive, expensive federal FHA compliance training, overseen by a neutral third party. The HOA was also required to hire an independent, court-approved FA consultant for 3 years to review and pre-approve all future rules and amendments pertaining to accommodations, forever eliminating Kline's arbitrary power. The total financial hit EDCUD fines, compensatory damages, legal fees, and mandatory compliance costs succeeded a colossal $300,000. The entire operational and legal reserve of the HOA was instantly wiped out. The board, having been personally named in the federal suit, faced individual professional risk and liability. They were forced to initiate a massive, non-optional, emergency special assessment on every single resident to cover the court-ordered fines and judgments. The community, which had once supported Kline's vision of exclusion, descended into financial and social revolt, with furious neighbors now facing a $4,000 bill each due to the board's illegal arrogance. Robert Kline, the arrogant president who had dismissed federal law, was publicly censured by the federal court for his willful and malicious disregard for civil rights, and was immediately removed from the board and barred from holding office again. Amelia Hayes not only secured her right to live peacefully and fully participate in her community with Baxter, but she forced the entire community to fundamentally rewrite its governance under the unflinching, permanent eye of the federal government, ensuring that the Fair Housing Act became the ultimate, most expensive, and non-negotiable rule of the community.